diving in the lake yesterday, searching for a gun, and they found it.
Oh yeah, what kind?
A pistol. I couldn't tell. They put the tape up and kept me so far away. But it had to do with the shooting in D.C.
Mr. Maggart, can I turn this into you now? It's for you. It's for you specifically.
Yeah, you can tell me people what they get.
They can if they want.
Sure.
Just turned in my motion to recuse the judge for conflict of interest, as he told me never to speak to him ever again.
County, you have a chance to review what Felix wanted %?
Yes, I have, sir.
I haven't seen it yet. I just asked if he wanted to share it with you over 40% of it. So if you have the ability to get
No, he hand delivered us a copy this morning, so I have it.
Okay, you
It's
mind
not a
providing
copy.
me-
That's the only one I got.
Do you mind providing me?
Oh, you do not have it.
I want to make sure you saw it too. So everything that's submitted. you want to make any argument based on your motion?
You told me never to speak to you again. There's a conflict of interest between you and I. You claim that I threatened you by exercising my constitutional rights in front of your law firm, and you were so worried about it that it influenced your decision. So I can't get a fair trial with you, obviously.
County?
I did review the motion this morning. The rule that Mr. Filax is citing to is rules of judicial administration. So again, applies to judges and courts. You're failing to recognize this is not a judicial proceeding. I think the best standard to govern this proceeding is, Mr. Maggard, you're an extension of the Board of County Commissioners, essentially is sunshine law. So when does a commissioner have to recuse themselves from a proceeding? It's not the standard articulated in the judicial rule about what would a reasonable person believe, but rather, is there a conflict or an appearance of a conflict of interest? The closest I could find was Florida Administrative Rules 12D 9.022, which governs special magistrates for property appraiser hearings, and that is the standard that's articulated. So I would argue that, to my knowledge, special magistrate, your only interaction with this appellant is in the context of these hearings. Yes, there was a prior case over the summer that did not resolve in his favor. This is a new case, new witnesses, new evidence. I don't know how having a prior case in a similar forum rises to the level of a conflict of interest.
It's not about having a prior case. It's about our email exchange where you told me never to speak to you again and that I was threatening you and that you're going to take action on my threat. It has nothing to do with the prior case.
Well, I don't think I, first of all, ever said never to speak to me again.
I can show you the email right now, sir, if you'd like. Would that help you remember?
Fine, if you want to present something.
Oh, I'll gladly show you the email where you told me never to speak to you again or contact you again. And that you were going to take action against me as a threat. So there's an obvious conflict of interest here.
I do remember the exchange after the last hearing.
Correct.
So it was after the decision was already made.
Correct.
And you wanted to readdress it, and I kept referring you back to the county, saying that my engagement for this matter was done. Once I signed the order, you need to contact the county.
And you refused to show me where it says I need to contact the county after I asked several times. I don't know why I would contact a prosecutor who was working against me. That doesn't make any sense to me.
Once I ruled on the prior hearing,
Would you like to see this?
I didn't have any ability to do anything.
Would you like to see your email? Your threat has been noted and is being reported. Do not contact me again.
May I look at the email?
Go ahead. You were worried that I was going to protest in front of your lawyer's office and disparage you in some fashion or form. I would have contacted you and sent you this paperwork, but you told me never to contact you again. So you're also diminishing my ability to get due process.
Yeah, I think it's clear that my context was in regard to the prior order that you kept.
What threat did I make?
To readdress.
What threat are you claiming I made towards you?
I'm not sure. I don't even remember the incident, so I'm
Well,
clearly not.
there's a clear conflict of interest.
Well, if I don't even remember what it was, then I don't think it's a conflict.
It's not based on your memory, sir. It's based on factual evidence I just showed you.
Yeah. Well, I'm going to deny the request for recusal because I don't think it's making me important.
Okay, then I'm going to have to refer to I refer you to the Florida Judicial Qualifications Commission because there is a conflict of interest. You told me never to speak to you again. You clearly have a bias against me, and you claim that I threatened you when I never did such a thing. There's a clear bias against me and a clear conflict of interest. If you move forward with this, I will report you to the commission. There's no reason I can't have another hearing officer.
County, do you have anything?
I mean, it sounds like what we're talking about is an ex parte communication after the last case closed. So
Irrelevant.
I would agree that that's improper communication.
Irrelevant.
We're here in a formal proceeding now. We're on the record. It sounds like Mr. Maggard was requesting not to be contacted ex parte. I don't think that rises.
Claiming a threat.
Obviously, if you feel it's appropriate. Yeah, I would say the Judicial Qualifications Committee does not have jurisdiction over you. You're not a judge. If you think it's appropriate that there's an appearance of a conflict, then Mr. Filax would have to waive his right to the hearing within 30 days, as that expires later this week, and we don't even have another hearing officer to contract with. We would have to seek one out. But
I've given you plenty of time to seek another magistrate out. You told me to bring it up at the hearing. I would have brought it to your attention sooner, but I was told never to speak to you again because you claimed that I threatened you when I never did such a thing.
I think you're taking that out of context.
Sir, would you like me to read it verbatim to you again?
No.
Okay. You claim that I threatened you, that you're going to take action on my threat towards you, and to never talk to you or contact you again. That is a clear conflict of interest. Plain as day. There's no reason you can't hire another magistrate for a special session, other than you don't want to. And that's not the only thing. You also ignored all the case law I presented last time.
Yeah, the disagreement on how the law applies is not a conflict. And also,
Okay.
me telling you not to contact me.
Based on a threat. Don't forget that part. Based on a threat I never made.
Like I said, I don't recall.
Regardless of your memory, sir, it's on paper, it's in writing, it's on the record.
I think the standard is whether I think that I can be fair and impartial, and if I don't remember that incident, I do remember you contacting me multiple times after the last hearing, and I told you you need to contact the county.
But you never told me what rule says I need to contact the county. The 66159 specifically says that you have continuing jurisdiction. It says nothing about them. Who else would I contact if not you? They're against me. You're supposed to be unbiased. So why would I call a person who's working against me? That doesn't make any sense. And nowhere in the paperwork or 66159 does it say I need to contact him for paragraph 7 of 66159. I contacted you, you claimed that I threatened you, and you told me never to speak to you again. There's a clear, obvious bias here and a conflict of interest. Clear as day. And if the commission doesn't have jurisdiction over you, I'll find the commission that does have jurisdiction over you. You move forward with this, it will be an unfair trial, 100%.
County, do you have any follow-up?
I don't think what he's presented rises to the level of conflict of interest. There's an adverse ruling, and he was instructed not to conduct ex parte communications.
Based on what? Your opinions? There's nothing on paper, there's nothing on record says I can't contact him. Ex parte is something you guys decided to use. I've never used that word. I used your public email, which I was instructed by Sam Boundy here, to contact you through your email I found on Google. I was instructed by him to contact you. I can show you that email too if you'd like.
I don't think the problem is that you contacted me so much as once I told you to contact the county that my involvement's done, that you kept contacting me.
Your involvement is done based on what? How is your involvement done? Chapter 7 says you have concurring jurisdiction after the case is over. It doesn't say anything about me having to contact the person who's working against me to speak to the person who has concurring jurisdiction. That's you alone.
I think we have a disagreement with the
Well,
law. I don't think it rises to the level of conflict. So if you want to proceed today,
I would ask to proceed. I don't have concerns that it rises to a level of conflict.
I do. I have major concerns, and I will follow up to the end if you proceed with this trial. There is a conflict of interest between you and I. You also claimed over a phone call that I was threatening you, and I never threatened you once. You're claiming that I've threatened you multiple times, and I haven't done it once. Not one time.
like I said, I don't recall.
Regardless of your memory, sir, it's on record. It's in writing.
I don't think that there's a legal conflict. I don't.
There absolutely is a legal conflict. You've claimed that I've threatened you and to never speak to you again. So am I allowed to speak to you right now?
Yes, I told you to stop emailing me.
That's not what you said.
In the prior emails before that, I did multiple times.
Why would I stop?
Emailing me, and I said, stop.
Why would I stop emailing the magistrate who has concurring jurisdiction under 66159 and was told by the county attorney to specifically contact you? You should not push through with this. It's only going to get worse. All you need to do is reset this with a different magistrate and a different set of eyes. It's as simple as that. I tried to tell him ahead of time. He said, no, just bring it up now, and here we are. Instead of figuring out beforehand, we're sitting here with all these people here and all this tax money being wasted, arguing the point. There's a clear conflict of interest. You claim that I threatened you more than one time.
I've decided that I don't think there's a conflict.
There is a conflict. I've decided there is a conflict, and I've showed you the paperwork and the proof.
And after this hearing, you can appeal it to circuit court.
According to him, I can't appeal unless I hire a stenographer.
I can't speak to the rules on that.
Okay.
I believe that a recording of the proceeding can be transcribed.
Not according to Mr. Boundy.
I'm telling you that if you have a recording of the proceedings, you can have it transcribed and submit it with your appeal.
Okay, sir, but you should not proceed with this. There is a clear conflict of interest between you and I. And I do not feel I can get a fair trial with you as the magistrate here today.
I understand your objection, but I disagree. I think that can be fair and impartial.
I disagree. Obviously, you haven't been so far.
Let's have a hearing in the circuit.
Let's not have a hearing because you have a conflict of interest. And I demand you recuse yourself.
I'm not recusing myself.
Okay. So you're going to go forward with an unfair trial and a biased trial, even though you told me never to speak to you again.
Like I said, you can appeal to the circuit court. The circuit court agrees with you that they think there's a conflict.
There's a clear conflict.
Then they will make that ruling, but I don't think there's a
So you claiming I threatened you when I didn't is not a conflict of interest.
I've already decided that.
You've decided for yourself that even though you've said that I've threatened you,
And that I'm not recusing myself, I don't think there's a conflict.
even though you said I've threatened you.
Mr. Brown, do you have anything?
Why can't I reschedule this with a fresh pair of eyes and a new magistrate? I don't understand that. What's the problem with that? Why do you insist on taking this case after we've had problems with each other?
I'm doing my job. I'm hired.
Part of your job is to be unbiased.
I am unbiased. That's what
You're not. You claim I've threatened you.
like I told you, it doesn't affect my ability to hear the evidence today.
I think it does. Of course it does.
I remember that. I remember you.
Sir, your memory doesn't matter.
It does. That's the whole.
I remember that you did do that. I remember that you did. And I showed you evidence and proof with your own words and your own actions.
Okay. You want to proceed?
No.
Yes.
I understand you guys want to proceed because you're the only contracted lawyer, but there's a clear conflict of interest here.
Okay.
And I cannot get a fair trial with you as the magistrate.
Your objection's been noted. We're going to proceed. You can participate or not participate. It's up to you.
Okay. Even though there's a conflict of interest, you're still going to proceed with this hearing.
We have a larger problem at this point. It seems the appellant is not willing to abide by the rulings of the magistrate. As you've indicated, he's welcome to exercise whatever appellate rights are appropriate. The ruling's been made several times now. And Mr. Felix is at this point
I'm objecting to your ruling. It's obvious there's a conflict of interest.
Right, there's a procedure for objecting to a ruling, and that's appealing it to a circuit court order. There's an appellate division in circuit court, and that's where it would go.
So I need to take you to court.
You would take my decision theoretically to court if you
Okay.
disagree with it.
Okay, I object to these proceedings going forward with you as my magistrate as there's a clear conflict of interest. If you proceed, that's on you.
Your objection's been noted, and I've overruled your objection.
Okay.
So,
Shocked.
before we begin the proceeding, I would just ask that Mr. Maggard, that you swear in anyone who may potentially be giving testimony today.
Do you have a clerk that can administer the oath?
All the witnesses stand. Raise your right hand. You swear to tell the truth, the whole truth, and nothing but the truth? Yes. Thank you.
I'm not inclined to give an opening statement. I would waive that, but I did file a motion to dismiss that I'd like to address briefly. Okay. Based on the timeliness of the issue before we call on the witnesses. So I filed a motion last week based on an on-timely appeal, specifically section 66-159 sub 6 sub A of the Pasco County Code of Ordinances states that an appeal of a trespass warning must be filed within 10 days of the issuance. So the trespass warning that is the subject of this case was sent via certified mail on February 12th, 2024. A copy of that was attached to the motion. I also have Corporal Zalba here who had it sent out, and he can testify to that as well. The county attorney's office received an appeal of that trespass warning on March 5th, 2024. So the appeal clearly was not filed within 10 days of issuance. It was filed 22 days after it was issued, over 3 weeks after it was issued.
Objection.
Objection.
It was not issued on the 12th. It was issued on March. I think I showed up there on the 5th. It was issued the Friday before. I was there 3 days after it was issued to me. It was not issued to me till March something. They tried to deliver it, but it never happened. I also have video of Mr. Boundy. It's a minute-long video of him specifically saying that you're not served until it's in your hands, and there's nothing to appeal until then.
Let him get to his motion, because
Sure.
you can make an argument, but I think you're making an argument more than an objection. I don't know that I can.
Yeah, just,
I mean, there's nothing for me to rule on. Because your argument, once he's done presenting.
Right, and I mean, that's just a procedural matter. And in response, I'll still have an opportunity to respond to the motion of any hearing objection. So, I mean, ultimately, from what he's saying, I think there's probably a disagreement over the term issuance. He's arguing that he didn't get it until a few days before he filed the appeal. That is 100% correct. I will stipulate to that. I believe he went and picked it up 5 days before he filed the appeal. However, the ordinance says the clock starts when the trespass warning is issued, not when it's received by an individual. I understand the argument that would raise notice concerns. How someone's supposed to appeal a trespass warning if they don't know about it. But the problem in this case is that Mr. Filax was very much aware that the trespass warning had been issued, and he was
Objection. I was not aware. That's a false statement.
You can tell me that during your argument.
Okay.
If it's a legal objection, I'll hear it. If it's different in factual position,
Okay.
you have a chance to respond.
This is why he was aware. On February 8th, 4 days before the trespass warning is even put in the mail, law enforcement's at his residence trying to serve it. Again, Corporal Zell was here to testify to that if needed. And then on the 12th, 4 days after that, Corporal Zalba has a phone conversation with him and tells him they are attempting to serve him with a trespass warning, at which time he states, just send it in the mail. Corporal Zalba can testify to that as well. So this is February 12th, that phone conversation, 22 days before his appeal is filed. Every indication that he knew about it. I've attached to the motion an exhibit, an email that he sent to me on February 13th, where he stated the Wesley Chapel Tax Collector's Office is trying to trespass me. Again, 21 days before filing his appeal, showing that he knew about the trespass warning. This is also an experienced litigant. He's been through this process before. He's filed trespass appeals in this very tribunal before. He's not new to this process. And then we have attached to the motion the United States Postal Service printout as well, that they attempted to deliver at his residence on February 22nd, 2024, and left a notice of the attempted delivery. So that's February 22nd. He has notice from the Postal Service. We're trying to deliver this. We need you to sign for it. Everybody's familiar with the card they leave when they're trying to deliver certified mail. And even with that, he waits 12 days from that to file the appeal. So even when you give him every benefit of the doubt and you wait to start the clock, not when it's issued, but when they leave notice at his door, he still waits 12 days. Now, he's gonna say in his argument, and he's already said, well, Sam Downey's on video saying that to cammed up caveman, you don't have a trespass warning, I don't consider you served. The problem with that argument is he can't claim to rely on what a county employee, even myself, told somebody else in a different case with different circumstances. No county employee, myself included, can justify a deviation from the code that would produce an illegal result. And that case, I would argue, is very distinguishable. That's a case where the sheriff's office had been advised to withdraw the trespass warning. A case that, to this very date, I've never seen a trespass warning that was issued, and have no evidence that a trespass warning was issued. It's also a different form back then. It didn't even have a date of issuance on the form, which we do have in this case. In this case, he spends 22 days between the mailing of his appeal and the mailing of his warning and filing his appeal, telling everybody who will listen that he knew about the trespass warning. So it's not a fair comparison to compare it to someone else's case on a different time and a different matter. The appeal in this case was not timely, and as such, we should not even get to the merits. Frankly, the county attorney's office contemplated rejecting this as untimely without a hearing, but determined that to the extent that there's any other interpretation, to the extent there's any ambiguity, that we should put this issue before the special magistrate. But I would argue that there's no ambiguity. The ordinance says the appeal must be filed within 10 days from issuance, and he filed it 22 days after issuance, all the whole time knowing all about it. So we would ask that the appeal be dismissed for untimeliness. I compare it to, we do demolition appeals all the time. The ordinance says you have 30 days from when the order is issued to file your appeal. And people come in all the time with late appeals and, well, I didn't know about it. But the standard's not, did you have actual knowledge? It's knew or should have known, constructive knowledge, which was accomplished in those cases through postings and through certified mail, which was done in this case. So again, for untimely appeal, we're asking that the appeal be dismissed.
Let's see. I did not know it was a trespass appeal. I went and did an open public records request, and the only thing they gave me was the fact that I was being charged with trespass, not that I was getting a trespass warning. As far as Zalva here and the phone call, they could say whatever they want. The Supreme Court ruled that the police are allowed to lie. So there's no reason for me to give them any credibility for what they say. The only thing I knew that whole time was that I was being charged under 810 of the Florida statutes for trespassing on curtilage of the property. That's what the records were given to me. Up until the second I had that trespass warning in hand, I had no actual knowledge that I was being given a trespass warning, other than hearsay from police who are allowed to lie under the law. That's not a credible thing. One document says I'm charged for trespass under 810, and then the paper I got in the mail says, no, you're issued a trespass warning under 66159. So there's no way I could know which is which until I open the envelope. The public records request that I made said I was being charged with trespass under 810.
So the public records request was 810, so that's Florida statute 810. So
Trespassing on curtilage.
Criminal trespass.
On curtilage, that I was being charged with that.
Okay.
On the phone they said no, I was being a trespass warning. Why would I believe cops who are allowed to lie by law versus the public record that says I'm being charged under 810? There's no way for me to know exactly what I'm being charged with or issued with until I actually open the envelope and read the documentation. And for him to say that I've told everybody I know, who does he know who I know and who I told? That's a false narrative and a false statement, to put it lightly. The only time I knew that I was had a trespass warning